Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. Here's a case every law student needs to understand. Have you ever wondered why some promises are legally binding while others are just words? In contract law, it all comes down to consideration. Today, we're breaking down the landmark cases that define what makes a deal real, helping you spot red flags in business agreements before they become expensive legal disputes. Alright, let's start with the real-world problem. Understanding what counts as value in a contract is the first step to ensuring your business agreements are actually enforceable. In the case of Curry v. Misa, the court defined consideration as either a benefit to one party or a detriment to the other. Think of it as the price paid for a promise. If you aren't giving something up or gaining something specific, the law might view your agreement as a mere gift. This matters because gifts are generally not enforceable in court if someone changes their mind later. A contract is essentially a two-way street where both parties may want to bring something to the table. If one person promises to do something for absolutely nothing in return, that promise usually lacks consideration. When reviewing a business deal, look for the quid pro quo, the specific thing each side is sacrificing to make the deal move forward. A common mistake is thinking a third party can provide the consideration for you without specific legal structuring. Generally, the person who wants to enforce the promise may want to be the one who provided the consideration. If a partner provides the value but you try to sue on the contract, you might find yourself without legal standing. Law doesn't care if you made a bad deal, only that you made a deal. Let's look at why fairness in price isn't a legal requirement. This famous case involved chocolate bar wrappers being used as part of the price for a music record. The court held that even though the wrappers were thrown away, they still constituted valid consideration. This teaches us that the courts won't protect you from a bad price as long as something of value was exchanged. The legal system prioritizes your right to value your own assets however you see fit. If you choose to sell a high-value asset for $1, the law will generally respect that choice. This is why it's vital to perform your own due diligence on market rates, as the court won't bail you out of an undervalued agreement. In many corporate restructurings, you'll see assets transferred for $1 and other valuable consideration. This is a deliberate tactic to satisfy the legal requirement of sufficiency without reflecting the actual market price. Always check if a nominal fee is included to ensure a transfer of ownership is legally robust. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. One of the most frequent ways contracts fail is when people try to use something they already did as the basis for a new promise. In Re McCardle, a family member did work on a house and was later promised payment for that work. Because the work was finished before the promise was made, the court ruled the promise was unenforceable. This is past consideration, and it's a major red flag in business. Always get the promise in writing before you start the work. There's a narrow exception where an act is done at the promisor's request with an understanding that payment would follow. If you ask someone to perform a service urgently, even if the price isn't set until later, the court may still enforce it. However, relying on this exception is risky and expensive to prove in court. This case refined the rules for when past acts can count as consideration. It requires that the act was done at the promisor's request, that payment was understood to be due, and that the payment would have been legally enforceable if promised in advance. It's a complex three-part test that usually requires a qualified legal professional to navigate. Can you be forced to pay more for something someone is already supposed to do? This is where contract variations get tricky. When sailors were promised extra money to finish a voyage after some crew members deserted, the court said no. They were already legally obligated to meet the emergencies of the sea. This means you generally can't demand more money just to finish the job you already agreed to do in the original contract. This modern case changed everything by introducing the practical benefits concept. If a party agrees to pay more because they want to avoid a penalty clause or ensure a project finishes on time, that practical benefits might count as consideration. This is a nuanced area where you should be very careful before agreeing to price hikes mid-project. Even if there's a practical benefit, a contract variation is void if it was obtained through economic duress. If someone threatens to walk off a job unless you pay more and you have no other choice, that agreement may not hold up. Recognizing the line between a negotiation and extortion is critical for project management. If a public official, like a police officer, does something that's already part of their public duty, they can't claim consideration for it. However, if they go above and beyond their legal requirements at your request, consideration may exist. Knowing where a public service ends and a private contract begins can save you from unnecessary costs. Now that we know the law, how do you apply this to avoid mistakes and protect your interests? If you want to make a promise binding but there's no clear consideration, you can use a deed. A deed is a specific type of legal document that's signed, witnessed, and delivered. It bypasses the need for consideration entirely. This is a safe first check if you're worried about the enforceability of a one-sided agreement. When changing a contract, always ensure both sides are giving something new. If you're extending a deadline, perhaps the other party offers a small discount or a change in scope. These mutual variations are much harder to challenge in court than one-sided changes to the price. Sometimes, even without consideration, a court might rethink someone from breaking a promise if the other person relied on it to their detriment. This is a complex shield, not a sword legal doctrine. If you find yourself relying on a promise that isn't in a formal contract, call a professional immediately to see if estoppel applies. Disputing consideration is often a high-cost endeavor. Before heading to court over whether a practical benefits existed, compare the legal fees against the contract value. Often, it's cheaper to renegotiate a clear new contract with fresh consideration than to argue over the validity of an old one. You should consult a licensed attorney whenever you're dealing with high-value variations, settlements of disputed debts, or complex international agreements. A quick review of your consideration clause now can prevent a total contract collapse later. Don't wait until you're in a dispute to check if your deal is actually a contract. That's the practical version of what matters most. The big idea is to understand the problem, compare the right details, and avoid rushing into an expensive decision without context. If this helped, like and subscribe for more Law Conquer practical guides that help you compare costs, understand legal principles, and navigate your business with more confidence. If this helped, like the video and comment with the next case you want summarized. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.